Hey, durian lovers and legal eagers, have you ever heard about the Musang King crisis that brewing in Raub, the birthplace of Malaysia's most prized durian? The Malaysian Musang King crisis has exposed a deep tension between the legal formality and social justice. In Raub, the farmers who cultivated the land for decades under the government Green Book program has now faced evictions despite investing years of labor and paying the land use taxes. Over 15,000 of durian trees has been destroyed and public outcry continues to grow. I am Hai Junwei, alongside with Lai Changze and Te Wei to present a research proposal of reforming the land law for justice. The main content of presentation is divided into four essential discussions. First, we will explain about the Malaysia current land law under the National Land Code 1965, which strictly follows the tolerance systems and explicitly bars the land ownership through adverse possessions. This is supported by landmark cases such as the Sidak bin Haji Muhammad and the government of Perak, which squatters lost their land despite decades of occupations. In contrast, I will explore on how other countries, such as United Kingdom in the case of J.A. Pai and Graham, and the Philippines through the Land Regulation Acts, and Thailand from the policy of Sor Porkor, have implemented the legal or policy reforms to recognize the long-term occupiers and ensures the social justice. This comparison serves to highlight that while the tolerance system offers legal certainty, it can and has been adapted to protect the vulnerable communities. Musang King crisis is more than just a durian dispute. It is a mirror that reflecting on how law can serve or forsake its people. Malaysia's land policy remains intricately layered, with historical programs often clashing with later statutory reforms. These tensions raise three fundamental research questions. First, should the adverse possession be reinstated in Malaysia? Second, should the individuals be penalized for administrative errors or outdated laws? And third, can the public expectations or principle of equity bridge the gap between the rigid statutes and the genial justice? To explore these issues, these studies will examine the feasibility and the design of potential squatter regulation acts that could grant a long-term cultivators a transparent, conditional route to former title. The research will assess the criteria such as the sustained occupations, the community investment, good faith efforts to regularize the claims while considering how such reforms might preserve the tolerance system's core integrity. Our research pursues three interconnected objectives. First, we will critically evaluate the necessity and legitimacy of reinstating the adverse possessions in National Land Code by benchmarking our tolerance-based systems against the international models such as the Brazil's Uso Capial, the Philippines' Cadastral Program, and Thailand's Sor Porkor. Second, we will investigate on how imperfect legislations can unduly penalize the citizens by tracing the legacy of Green Book program and identifying the legislative, administrative, and judicial safeguards that might shift the accountability back to the state. Finally, we will explore on whether the principle of equity and public sentiment can catalyze the policy reforms to restore the land rights to hardworking cultivators, including surveying the stakeholders' view on alternative tenure solutions. Next is our scope of research. Legally, the study conducts a doctrinal analysis of Section 48 of National Land Code 1965 of Malaysia and the relevant Malaysia case law, supplemented by comparative reference to UK, Philippines, and Thailand law. Temporally, it spans from 1960 Green Books program through the 2025 Raub evictions. Geographically, it focuses on Raub Pahang, which selective foreign comparisons. Methodologically, it combines doctrinal legal analysis with comparative law underpinned by the tolerance system theoretical framework and concludes with a normative assessment to highlight the deficiencies and the proposed reforms. Next, I would like to pass to my partner K.K. Ray to continue present on how the method is used to do the research.
In our research, it involves many methods for extensive data collection and analysis. In this research, there are four main types of research we use. The first one is the doctrinal legal research. Doctrinal legal research is a research that analyzes existing provisions of the statutes and cases using the power of reasoning. In our research, we analyze the land law of Malaysia, which is known as the National Land Code 1965 and the Limitation Act 1980. We also refer to the case of Merku Pusu Development Sendian Berhad versus Setara Jaya Sendian Berhad. The next type of research is comparative legal research. It is research that combines different areas of law and laws from different jurisdictions. For our research, we are going to compare the land law of Malaysia and English law. We also compare the judgment in Malaysian and United Kingdom cases. In this type of research, we will compare and find the similarities and differences between Malaysian land law and English law. Besides that, the type of research involved is critical legal research. It is a social justice-oriented critical intervention that provides a theoretical framework and practical application. In this research, we criticize the injustice in the land law of Malaysia in the case of the Raub durian farm dispute. We will also be criticizing the land law for a more human-centered law and propose reform for justice. The last research involved is quantitative legal research. This research is expressed in numbers and graphs. In our research, the data we collected from the survey show the results in numbers and graphs. This helps us to understand the tendency of respondents regarding their opinion on whether they feel justice under the land law in situations similar to the Raub durian farm dispute. Through the research we do, there are many forms of data we collected. In this data, it separates into two types of categories of data, which are primary and secondary data. The first is primary data. This kind of data is obtained firsthand by the researcher themselves, and the data collection time is long. The primary data we obtain is the responses from the survey. A survey is a way to collect information by asking questions to a group of people to understand the larger population. There are many ways for surveys to be done, and our group chose an online survey using Google Forms as our medium. For secondary data, it is data that collected by someone else earlier, and we collect it from existing sources. Its collection time is short, and it is easy to collect. The first secondary data we use is case law. It's created when judges apply and explain existing law in specific cases. For this kind of data, we collect it to compare the judgments in Malaysian and UK cases. Other than that, the secondary data we use is news. The news is a report of a recent case. We learn about the dispute over Raub's durian farm through the news. It is very good secondary data, provided by a trusted author and publication. It makes our data more credible. The last secondary data we use is statutes. A statute is a law enacted by a legislative branch of the government. For example, we refer to National Land Code and Limitation Act for our research. In sampling, we use stratified random sampling. It is a type of sampling that divides a population into smaller groups called strata, and these groups are made based on shared traits. In our research, we divide our respondents into two groups, which is law students and non-law students. We are going to sample 50 respondents and we'll see whether there's a difference of opinion on the question of unjustness in land law between the law and non-law students. The next one is limitation. We have faced several problems in our research. The first one is the willingness of people to fill in the survey. This problem occurs when they are afraid of leaks of personal information. For this problem, we try to make a declaration that we will only use it for research purposes, but it still depends on them to decide whether to trust it or not. Other than that, we also encounter problems with time management, where there are a lot of tasks that accumulate at the same time. We tried to solve this by identifying the most important tasks and do it first to avoid too many jobs that need to be done at a time. Lastly, we had to deal with our lack of knowledge about land law. We spent a lot of time learning about the subject before we could properly carry out our research. To overcome this, we focused specifically on the issue that our research was based on, which made the task more manageable.
Significance of research. We will present a critical and comparative legal study that questions the fairness of Malaysian land law, particularly how the current system excludes long-term occupiers like the Raub durian farmers. This research examines whether our land law protects legal titles at the expense of people who have lived, worked, and cultivated the land for decades. Our study contributes in three ways: to society, to legal practice, and to academic development. First, at a societal level, it addresses the imbalance between rigid legal provisions and the lived realities of farmers. In the Raub case, despite having state support under the Green Book initiative, farmers were later evicted for not holding registered titles. Their trees and livelihoods were destroyed. The question is, should the law prioritize ownership on paper over real-life contribution? Second, we aim to improve legal practice. Section 48 of Malaysia's National Land Code bars any claim to land through possession. This contrasts sharply with the UK's Land Registration Act 2002, which allows title claims after 10 to 12 years of uninterrupted occupation. Our research advocates for a hybrid reform, one that safeguards state land but also acknowledges long-term occupation with legal regularization or compensation. Third, in the field of legal academia, this research sparks necessary conversations about adverse possession in Malaysia, a topic rarely addressed in reform. We compare our law with England and regional neighbors to inspire future reforms and research that's more human-centered and economically responsible. In conclusion, the law must not serve the state or investors, it must serve the people. This research calls for reforms that recognize contribution, continuity, and community in land use. Now I will move to literature review that supports this argument. The literature review for this research centers around three themes: Malaysia's current torrents-based land law, comparative foreign models, and legal philosophical tensions around justice and land use. Malaysia follows the torrents system, where title registration equals ownership. Section 48 of the National Land Code clearly states that no title can be acquired by possession, no matter how long the land is used. Judicial decisions such as JH Capital versus Pentadbir Tanah Daerah Petaling show that courts uphold this formalism, often ignoring moral or economic contributions. In contrast, England allows adverse possession after 10 to 12 years under Schedule 6 of the Land Registration Act. This reflects a more equitable approach, valuing the land's productive use. Even more relevant are Southeast Asian models. In the Philippines, land reform prioritizes farmers' rights through redistributive policies. Thailand's so-called system is particularly noteworthy, granting farmers perpetual, non-transferable cultivation rights based on merit. If Malaysia adopted a similar approach, we could allocate idle or disputed lands to qualified farmers instead of leasing them to corporate monopolies that exploit those same farmers. Philosophers like John Rawls argue that justice must serve the least advantaged. Under the current system, long-term farmers, despite building our Argo economy, are labeled as trespassers. This is not just a legal issue, but a moral failure. The public trust doctrine supports this, requiring the state to act in the public interest, not private corporate gain. In summary, this literature helps us question, is our land law just on paper or in practice? Through legal reform and public accountability, we can ensure that our land reflects not just titles, but the toil and trust of the people.
Thank
Thank
you.
you.